McGahn subpoena fight to test limits of executive immunity. Breaking news. The impending court battle over a congressional subpoena for President Trump's former White House counsel Don McGahn is about to test the concept of immunity for top presidential advisors, which has been invoked by both Republican and Democratic administrations but hardly tested in courts. Legal experts say that the outcome of a court battle between the House Judiciary Committee and the White House over McGahn documents and testimony could have significant implications for the powers of Congress and the executive branch. The court fight could take months, even years, to resolve, further frustrating House Democrats as they seek to follow investigative threads from Special Counsel Robert Mueller's Russia probe. The Trump administration says that McGahn and other White House advisors are absolutely under the standard of immunity. The administration argues that current and former staffers aren't required to disclose what took place in the White House, pointing to the confidential protections offered to the executive branch. But Democrats say the assertion has no basis in law and is therefore moot, and that the White House is leveraging the argument in a sweeping fashion in order to defy their investigative pursuits. It's former Trump Communications Director Hope Hicks from answering more than 150 questions during an interview behind closed doors on June 19 by asserting her immunity from testimony, an episode that infuriated Democrats, who now believe the transcript of her testimony demonstrating the White House's objections will strengthen their argument in court. Judiciary panel Democrats say Nadler could file a lawsuit in the D.C. District Court. Trump instructed McGahn to resist his subpoenaed appearance in May, citing a newly minted Justice Department Office of Legal Counsel OLC opinion stating, Congress. The opinion cites a 1971 memo written by then Assistant Attorney General William Rehnquist during the Richard Nixon administration as first laying out the legal basis for immunity, as well as several executive branch opinions written thereafter. There is virtually no case law on the immunity concept, which experts view as an outgrowth of the notion of executive privilege. U.S. District Judge John Bates ruled against the George W. Bush administration in July 2008 when it tried to assert blanket immunity to prevent former White House counsel Harriet Miers and then White House Chief of Staff Josh Bolten from testifying before Congress under subpoena. The court ordered them to appear but said they could still make specific executive privilege assertions to evade certain questions. However, the court issued a stay pending appeal, and the parties eventually settled on an agreement the following year for Miers to testify behind closed doors, and the case was dismissed. Still, either branch of government faces a risk of losing and establishing a precedent that could threaten their powers going forward. Jack Sharman, a former special counsel to Congress during the Whitewater investigation, noted that, generally, there have not been many judicial opinions concerning struggles between the legislative and executive branches over congressional oversight requests, and that in most cases the two sides resolve the dispute outside of the courtroom. Sharman also said that executive power has generally increased over the last several decades, apart from a handful of what he termed retreats of presidential authority. Nadler has launched a sweeping investigation into alleged obstruction and other potential abuses of power by Trump, seeking testimony from key Mueller witnesses including Hicks, McGahn, and McGahn's deputy Annie Donaldson. The panel will have the opportunity to publicly question Mueller himself on July 17. The White House has accused Democrats of pursuing a do-over of Mueller's two-year probe, which did not establish conspiracy between the Trump campaign and Moscow and did not reach a conclusion on whether Trump obstructed justice. Democrats are hopeful that a court victory to enforce the McGahn subpoena will help them secure testimony from other witnesses and erode the White House's efforts to resist the congressional investigation. A committee aide did not respond when asked about the timing of the lawsuit. Still, a court fight would be tedious, potentially delaying any testimony from McGahn for several months, even if Congress is ultimately successful. Some Democrat, Jacqueline Thompson contributed.
Raindrop, drop top, smoking, no cooking the hot pot. Fucking on your bitch, yeah, that. Looking up, open the park pot.